Heyo, folks, and welcome. There has been development in Mr. Steele's appeal of his contempt of court. As you remember, the ex parte meeting on June 10th, 7th, possibly more, is what set everything off regarding Judge Glanville getting yeeted and, well, got to where we are today. So, what can I say? The state does nothing to do with this appeal. Absolutely nothing. They are hiding under a rock or just running away from it because they know they're participating in the ex parte meeting looks really bad. They got a desired outcome from Judge Krause's idiotic ruling that nothing in that ex parte meeting was, according to her, was nothing wrong, which is appallingly bad. But now we are here for the state. They find this with the Supreme Court. Let's see, let me find. It says, appellant Brian Steele appeals from an order of criminal contempt issued by the Chief Judge of the Superior Court in Fulton County. They don't even mention his name. Although it is criminal in nature, this is not an appeal from a criminal conviction in which the state of Georgia acted as a prosecutor. The state of Georgia announces that it does not view itself as a party in interest of the current appeal and for that reason does not intend to file a substantive response to the brief of appellant. Now, they were all for Mr. Steele being held in contempt. All for it. And now all of a sudden, we don't want anything. No, we had nothing to do with it. Please don't make us write something about it. And for that reason does not intend to file a substantive response to the brief of appellant. In a letter to the parties notifying them about potential conflicts of interest, Presiding Justice Peterson wrote, quote, "This appeal is not an appeal from the underlying case, but a collateral matter between the trial judge and the defense lawyer in which the district attorney's office has little cognizable interest, at least as I understand the matters at present." A letter issued July 11th, 2024. And as per usual, if my recollection doesn't fail me, that quote is a bit taken out of context. The state agrees with the presiding justice's initial assessment that it lacks a cognizable interest in this appeal. As such, the state does not assert a position in support of or in opposition to the merits of this appeal. The undersigned feels compelled to note that the brief of appellant and the amicus brief both include assertions or comments regarding the underlying case, which the state does not believe are necessary for resolution of this collateral matter. Yeah, I wonder why. And I will read from the amicus brief. Oh, you're in for a treat. But first, let's get through this one. They are instead specifically germane to the underlying case. This includes, but is not limited to, lawfulness. Let's see, can you see that? Oh, sorry. Lawfulness of the June 10th, 2024 meeting in chambers. Footnote 1. 3 Superior Court judges have ruled that such meeting was lawful. The original trial judge Oh. Oh no. Oh no. Oh no, you didn't. You cite Judge Glanville. That's not a bright idea, but the original and the successor trial judge, I don't think that was a ruling per se, but I digress. Three Superior Court judges, the original trial judge and the successor trial judge, were likely lawful. The recusal judge. Oh, the recusal judge, that should be Miss Judge Krause. That meeting in chambers was a critical stage. Whether that meeting in chambers was a critical stage at which the defendant had a right to be present. Footnote 2. On the information and belief, the successor trial judge has ruled the meeting in chambers was not such a critical stage. I do believe she referred it to Judge Krause. I don't believe there is an actual ruling by Judge Whittaker. Again. Appellants glossed on specifically what occurred at that meeting, whether participant in the trial engaged in misconduct. Footnote 3. The state maintains appellant's assertion of misconduct on the part of the chief judge and the prosecutors are incorrect. Oh, of course you said that. And the basis for chief judge recusal, footnote 4. The recusal judge determined recusal was necessary based specifically on the chief judge's description of past events in making a record on the issue of recusal, which description occurred on July 1st. Such matters are specifically germane to the underlying case rather than this collateral matter, and information related to them is not adequately or fully included in the understandably limited record on appeal for this collateral matter. The state cautions against any language within this honorable court's ultimate decision of this appeal which the defendants in the ongoing criminal trial below might interpret as being binding on that criminal case itself through the law of the case doctrine. Translation. Please, Supreme Court, our case is weak as it is. Don't make it even weaker. Please. Ugh. I have a bad... Every time the prosecution puts something in writing, I get a bad taste. The state cautions against blah, blah, blah. The undersigned conveyed to counsel for Mr. Steele on August 2nd, 2024, the state's position that it is not a party in interest to the current matter and does not intend to respond substantively. In my personal opinion, this is about candor to the court. Ms. Love, Ms. Hilton, and all the others on the prosecution's table have an obligation if they know something is wrong. They chose silence. They didn't say a word about, Judge, this is wrong. Oh, yeah. They were very outspoken in how they have defended that ex parte meeting. And then they chose to stay silent, even though the rules are clear. The judge was wrong. And they said nothing. If this honorable court would like the state to take a position on any portion of this appeal, the undersigned will do as directed. Additionally, this appeal is scheduled for oral arguments on October 22nd, 2024. Should this honorable court prefer a representative from the state to be present for those arguments, despite not being a party in interest, the undersigned will make himself available for that purpose. Barring either development, the state simply wanted to provide this honorable court with this information and to make explicit its decision not to file a substantive response. Fanny T. Willis and Kevin Armstrong. Now, let's get to the more interesting part here, folks. Let's get to the more interesting part. The amicus brief from American Board of Criminal Lawyers. Amicus curiae in support of appellant. This is good. Let me make this bigger. In the Supreme Court of Georgia, Brian Steele appellant, State of Georgia appellee. Brief of the American Board of Criminal Lawyers as amicus curiae in support of appellant. Edward D. Tolley, Donald L. Semmel, Amanda R. Clark Palmer, members of ABCL. Table of contents, table of cases, introduction, interest of American Board of Criminal Lawyers, factual background, views of amicus curiae, conclusion, blah, blah, blah. Here comes receipts. Case law. Case law, case law, case law. Yeah. That's a heap of case law. Introduction. The American Board of Criminal Lawyers submits this amicus curiae brief in support of appellant Brian Steele. Judge Glanville's decision holding Mr. Steele in contempt is both procedurally flawed and substantively meritless and should be reversed by this court. The American Board of Criminal Lawyers was founded 46 years ago and is an exclusive national legal honorary society for outstanding criminal trial lawyers with admission to fellowship by invitation only. Members generally must have at least 10 years experience as a trial lawyer and have tried at least 35 felony jury trials or had equivalent courtroom experience. The standards for acceptance to ABCL include not just successful major felony trial experience, but exceptional recommendations from distinguished jurists and current fellows attesting to the candidate's high ethics as well as their litigation skill in criminal defense. The ABCL currently has 250 fellows. Georgia has 23 fellows. Past presidents of the board include Judge William Moore, Ed Tullen, Bruce Malloy, Frank Butch Martin, and Jerry Froelich. And then among the members are Brian Steele, as well as the authors of this brief, Don Samuel, Amanda Clark, and Ed Tolley. Other members include Larry Thompson, former Deputy U.S. Attorney General, Honorary William Moore, Manny Arora, Lynn Borsuk, Converse Bright, Drew Findling, Jerry Froelich, Ed Garland, Bruce Harvey. Hey, Bruce Harvey's in there. Christine Kohler, Paul Leitz, Bruce Malloy, Bruce Morris, John Osick, Bob Rubin, Jay Strongwater, and Lawrence Zimmerman. Bobby Lee Cook was also a member. ABCL is committed to the preservation and free exercise of fundamental freedoms for all those accused of criminal conduct. The amicus committee of the ABCL has authorized the filing of this brief in support of its fellow, Brian Steele, who was held in contempt in the Superior Court of Fulton County. Factual background. Jeffrey Williams, also known as Young Thug, is the lead defendant in the longest-running criminal trial in Georgia history. The trial is underway in Fulton County, and Judge Glanville was presiding until recently. The trial began with jury selection in January of 2023. Opening statements did not occur until November 2023. Brian Steele represents Mr. Williams. The indictment charges 28 people with various crimes, but in general is referred to as a RICO indictment alleging gang activity, including acts of ending drug dealing and assorted other violent crimes. The alleged gang is known as Young Slime Life, or YSL. An important witness for the state is Kenneth Copeland, also known as Lil Woody. Over the years, Copeland has been interviewed by police and provided information about alleged crimes supposedly connected to YSL. When called to testify by the prosecution, he started answering a few questions, but when asked how old he was, he invoked his Fifth Amendment right against self-incrimination. Subsequently, the state obtained a grant of immunity for Copeland. At first, Copeland still refused to testify, which earned him a weekend of incarceration at the Fulton County Jail for contempt. On Monday, June 10th, unbeknownst to the defendants or defense counsel, Copeland met with his lawyer, two prosecutors, investigators for the state, and Judge Glanville in Glanville's chambers. This meeting lasted for nearly 2 hours. In that time, the participants discussed Copeland's invocation of the Fifth Amendment, along with his displeasure about having been immunized and therefore forced to testify. Judge Glanville cautioned Copeland that if he refused to testify despite being immunized, he could be jailed for a lengthy period of time, perhaps as long as 2 years, until the last of the defendants in a sprawling RICO case were tried. I do believe Mr. Glanville was very vague with the length of time. Mr. Copeland expressed an unwillingness to testify and explained that he lied about everything, including his prior debriefing with the police, as well as his testimony that was planned for the trial. Nobody on the defense side was alerted that an ex parte meeting was occurring. When the meeting ended, the judge did not tell anybody on the defense side about the meeting. The prosecution, too, remained silent about what had occurred. Brian Steele, however, learned about the meeting. When the judge took the bench after a lunch break, ready to resume Mr. Copeland's testimony as if nothing unusual had happened, Mr. Steele said he had a motion he wanted to put on the record. Mr. Steele began making a proffer of what he had learned about the ex parte meeting. In the middle of the proffer, Judge Glanville interrupted Mr. Steele to demand how Mr. Steele learned about the meeting. Repeatedly, the judge asked Mr. Steele who told him about the meeting, at one point threatening, well, quote, "Well, listen, if you don't tell me how you got this information, then you or I are going to have some problems." Mr. Steele refused to answer on the basis that answering the question would violate privilege. In the resulting standoff, the judge would not tell Mr. Steele what had occurred, or what the witness had said, or what the judge told the witness, or what the prosecution said during the lengthy meeting. And Mr. Steele would not tell the judge how he learned about the existence of the meeting. Judge Glanville took a brief recess. He came back and continued to demand that Mr. Steele tell him how Mr. Steele learned about the meeting. Judge Glanville was concerned that a quote-unquote sacrosanct meeting or conversation was leaked to the defense. Judge Glanville believed this to be some kind of violation of Mr. Steele's part, but never identified what duty or rule that statute was violated. Mr. Steele tried to explain to the court why he believed that Georgia Professional Rule of Conduct 1.6 prevented him from revealing the source of his information. Judge Glanville then declared he was summarily holding Mr. Steele in contempt, but he also gave Mr. Steele until 5 p.m. that day to, quote-unquote, think about it. Though the phrase, quote-unquote, civil contempt was not used at the time, it was clear that is what was in Judge Glanville's mind, because he told Mr. Steele that he would be in custody until Mr. Steele revealed how he learned about the ex parte meeting and thereby purging his contempt. Yes, folks, that is the difference between civil contempt and criminal contempt. Civil contempt, you can hold somebody until they tell you what you want. Civil contempt is what Woody was in. You're in jail until you start testifying. In Mr. Steele's case, it was, tell me who snitched on the corrupt judge or you will be in jail until you tell me. While criminal contempt is a punishment for something you did. That's the difference. Mr. Copeland continued to testify that afternoon. It wasn't until after the jury was released. Oh, sorry. And Mr. Steele's attorney appeared in court and educated Judge Glanville on the difference between civil and criminal contempt. That Judge Glanville finally clarified he was finding Mr. Steele in criminal contempt for his refusal to answer the judge's question about the source of his information. The judge then sentenced Mr. Steele to the maximum allowable time in custody, 20 days to be served on 10 consecutive weekends during trial. Views of the amicus. 1. The in-chambers ex parte mid-trial meeting between Judge Glanville, the prosecutors, the testifying witness, and the witness's lawyer was improper. No privilege was violated by anyone, whoever it was, who told Brian Steele about the ex parte meeting in chambers. Judge Glanville never issued an order to seal the ex parte proceedings, nor did he instruct the participant to keep it confidential. The meeting itself was not covered by attorney-client or work product privilege. The only violation that occurred was the judge's violation of the Georgia Code of Judicial Conduct. Canon 2.9 is explicit about the duty of a trial judge to avoid conducting any ex parte proceeding unless necessary, and when necessary, what procedures must be followed. Judges shall accord to every person who has a legal interest in the proceeding or that person's lawyer the right to be heard according to law. Emphasis: judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following listed exceptions. And here are the exceptions. I have read this on a number of times on my other streams, so I don't think I need to get through them again. But in essence, you can do what the judge and the prosecution did. The facts in this case are clear, that there was no necessity to conduct an ex parte hearing. The witness had a lawyer, and neither the witness nor his lawyer had requested a hearing to address his continued Fifth Amendment assertion. This was not a case in which a party asserted a privilege and needed to address the assertion with the court to establish the propriety or bona fides or the asserted privilege. In this case, the prosecution sought the ex parte proceeding with the court, and neither the witness nor his lawyer expressed any interest in being there or consulting with the court. Allowing this ex parte proceeding to occur and to participate in the proceeding by addressing the witness and the witness lawyer, and allowing the prosecution to address the witness and his lawyer, and falsely advising the witness that if he did not answer the prosecution's question in court, he could be imprisoned for years for civil contempt, was unconscionable. Not only was the ex parte proceeding impermissible, but the court had no reason to fail to comply with Canon 2.9. The court first violated that canon by failing to inform the defense that a meeting was occurring. He then doubled down on the violation by failing to inform the defense about the substance of the meeting. In fact, the trial judge would not even release a transcript of the ex parte proceeding for more than 10 days, with no basis to withhold the transcript, during which time the witness continued his testimony. The trial judge then tripled down on the improper procedure when he realized that Mr. Steele had learned that the meeting had occurred in chambers. Rather than comply with Canon 2.9 requirement to promptly notify all other parties about the substance of the ex parte communication, including the exculpatory information revealed by Copeland, the judge refused to provide the parties with any information about the meeting with the prosecution and the witness, and unceremoniously demanded that Mr. Steele immediately identify the leaker who, quote-unquote, spilled the beans about the meeting. The judge decried the invasion of the quote-unquote sanctity of his chambers rather than applauding Mr. Steele's insistence that the judge comply with the Code of Judicial Conduct. All that the judge would say about his obligation to comply with the Code of Judicial Conduct was that the appellate court could deal with that later. This here, letting the appellate court deal with it later, that is such a coward's cop-out. Cowardice. We don't need coward judges. Let's continue. When nominated to serve on the Supreme Court of the United States, Chief Justice Roberts assured the Senate Judiciary Committee that a justice should not create law based on his own beliefs, but should do more than quote-unquote call balls and strikes. Should do no more than quote-unquote call balls and strikes. Chief Justice Roberts would be appalled that, in this case, Judge Glanville may have started out just calling balls and strikes, but he then walked out on the mound with the pitching coach and suggested to the pitcher that he should consider throwing more curveballs or brush the batter back. Nobody on the batting team was permitted to listen to the judge's recommendation to the pitcher. In fact, nobody even knew he was talking to the pitcher and giving him advice. That's a good analogy. Though it's the judge's duty to call balls and strikes, it is Mr. Steele's duty as a lawyer to call quote-unquote foul about this improper ex parte meeting. It was inevitable that Judge Glanville would be ejected based on his improper conduct. 2. Mr. Steele's refusal to reveal the source of his information was not contemptuous behavior. Dun, dun, dun. There was no obligation of any of the participants in the ex parte proceeding to maintain secrecy. The hearing was not placed under seal. There was no protective order. There was no statement, explicit or implicit, by the judge or any participant in the meeting that it was to remain a secret. Thus, there was no reason that any participant should hesitate to discuss with Mr. Steele or anybody else what occurred during the ex parte proceeding. Mr. Copeland or his lawyer could talk to anybody they chose to talk to. So could the prosecutors, who had a duty to reveal any Brady information that developed during the ex parte proceeding or any witness statement that fell within the scope of the Georgia discovery provision. Now, Judge Whitaker claims there was no Brady violation because, hey, you got it. That's not the Brady violation. You don't expunge the Brady violation by, oh, whoopsie, here you are. It's like saying, hey, sorry I broke your knee with a baseball bat, but I paid your medical bills. No, you still did the act. You still did the act. You still violated Brady. But not according to Judge Whitaker. Let's continue. In short, there was no basis for the judge to demand that Mr. Steele reveal who told him about the meeting. The judge actually had a duty to tell Mr. Steele and the other lawyers what happened at the ex parte meeting. The fact that a participant in the meeting told Mr. Steele that it occurred should have come as a relief to the judge. Instead, he decreed that whoever told Mr. Steele what happened during the meeting violated the quote-unquote sanctity of his chambers. Mr. Steele insisted that he would not answer the judge's question. He told the judge that he had a duty under the Georgia rules of professional conduct to maintain the secrecy of information that he learned during the course of his representation. The judge gave no consideration to Mr. Steele's assertion of privilege pursuant to Rule 1.6. Without conducting even a momentary inquiry into the basis of the privilege, the judge insisted, once again, that Mr. Steele immediately reveal who told him about the meeting, relying on his ethical obligation not to reveal a secret that he learned during the course of his representation of the defendant. Mr. Steele stood his ground and declined to answer. Incredibly, the judge then said, however Steele acquired the information he received, the disclosure violated the attorney-client privilege. Yeah, which is incomprehensible, given the fact that whatever was said during the ex parte hearing was said in the presence of the prosecutors and their investigators, as well as the judge's staff, the judge, and various deputies. The judge never explained his allegation that Mr. Steele had somehow gathered information that was subject to the attorney-client privilege. Despite failing to explain the basis for his allegation, Judge Glanville concluded, with no evidentiary support, quote, "I don't think you have cover at this point in time. I think you have blown your coverage at this point because I do think that somebody told you some things that violated privilege." Lawyers have a duty to zealously represent their clients. As Brendan Sullivan responded during Oliver North Iran Contra proceedings in the Senate, when he was discouraged from objecting to questions, quote unquote, "I'm not a potted plant. I'm here as a lawyer. That's my job." Lawyers in Georgia have never been potted plants. Brian Steele is surely not a potted plant. The lawyer's obligation in representing a client includes the duty to question erroneous rulings, improper procedures, and any other decision or conduct by the judge that the lawyer believes is subject to condemnation. A failure to do so may amount to ineffective assistance of counsel and possible bar sanctions for failing to zealously advocate on behalf of the client. Judges who abuse their authority may not hold a lawyer in contempt for declining to accede to a judge's unreasonable demands. The judge is not the king. The judge is not an authoritarian ruler who can create new laws and order lawyers to comply with whatever demand the judge chooses to make. A lawyer has the right and the duty to say no when the judge abuses his power. There was no basis to hold Mr. Steele in contempt based on his refusal to answer the judge's question. There was certainly no proof beyond a reasonable doubt that Mr. Steele's refusal to answer the judge's question, based on Mr. Steele's assertion of privilege, to say nothing of the lack of any reason why the judge was entitled to demand an answer, even if there was no basis for asserting privilege, was contemptuous. As explained above, there was no reason that any participant in the ex parte proceeding was prohibited from discussing what happened during the hearing. As a matter of law, the judge had a duty to disclose what happened. So did the prosecution, to the extent that any exculpatory or impeaching information or witness statement was revealed during the ex parte meeting. The judge's curiosity about who told Mr. Steele what happened did not support his inquisition into the basis of Mr. Steele's knowledge. Absent any proof that the judge had any basis for demanding that Mr. Steele satisfy the judge's curiosity, the court could not decide there was sufficient evidence that Mr. Steele was in contempt. Thus, even apart from the procedure in irregularities, to put it delicately, there was no basis to hold Mr. Steele in contempt. And here are a bunch of case law. 3. The refusal to answer Judge Glanville's question did not disrupt the trial and did not merit summary contemptuous proceedings. When Mr. Steele did not answer the judge's question about who told him about the ex parte meeting, the judge initiated the threat of contempt and then summarily jailed Mr. Steele. At that point, it appeared that the judge was jailing Mr. Steele pursuant to the court's civil contempt authority, explaining that Mr. Steele would be released when he answered the judge's question. Not even one page later in the transcript, the judge explained that actually he was holding Mr. Steele in criminal contempt. Summary contempt proceedings are only appropriate when direct contempt arises in the presence of the court and tend to scandalize it and hinder or obstruct the orderly processes of the administration of justice. With case law. Otherwise, the contemptor should be afforded a separate hearing on the issue of his alleged contemptuous conduct. In Hasty, because contempt is a crime, the evidence must, of course, support these findings beyond a reasonable doubt. When it comes to attorneys' in-court statements, this court has held that an attorney may be held in contempt of court only after the trial court has found 1. That the attorney's statements and attendant conduct either actually interfered with or posed an imminent threat of interfering with the administration of justice, and 2. That the attorney knew or should have known that the statements and attendant conduct exceeded the outermost bounds of permissible advocacy. There was no ability of Mr. Steele to appeal the judge's decision to require an answer to his question. Yeah, if you go back and watch it, the judge even tried to say that his decision couldn't be appealed. What a 2-hour word. This was not a case in which a lawful order had been entered by the court and the party had failed to appeal the order and then failed to comply. That situation may warrant a civil coercive contempt. Here, though, there was no ability to appeal the judge's scope of interrogation because there was no order to challenge. More problematic was the absence of any reason why the judge needed to know the answer to his question immediately. What better proof of that than the fact that after leaving Mr. Steele in jail for more than 45 minutes, the court decided to proceed with the trial, allowing Mr. Steele to come back into the courtroom, and the trial went through the paces. Thus, it is undeniable that there was no necessity for an immediate imposition of civil contempt, and absolutely no reason to then ramp up summarily criminal contempt proceedings. If the trial could proceed without any further relief, and without the judge learning the answer to his improper question, and the contempt proceedings could be deferred, there was no basis for ultimately conducting summary criminal contempt proceedings. Later that afternoon, after the jury was excused for the day, the judge held a brief hearing and held Mr. Steele in criminal, then civil, then back to criminal contempt, imposing a sentence of 20 days in jail, which Mr. Steele was required to serve on weekends for 10 straight weeks. During the course of the trial, the judge denied bond and required Mr. Steele to serve the sentence on the weekends for the next 10 weeks in order to not disturb the progress of the trial. Notwithstanding the fact that Mr. Steele valiantly requested that he be allowed to serve his time in custody in the Cobb County Jail, where his client was being housed, so that they could work together on the case over the weekends. The trial judge should have considered the chilling impact to Mr. Williams' right that jailing his lawyer during the trial would have had. No one can seriously contend that a lawyer can effectively prepare for trial from jail. First, there are the deleterious physical and mental effects of being in jail. One does not get to choose their diet, the time they wake up or go to sleep, or the ability to exercise. Then there are the practical impediments that being in jail presents. The lawyer cannot interview witnesses, either in person or over the phone. The lawyer cannot work on the computer, whether reviewing discovery or writing motions or researching legal issues. The lawyer cannot travel to various alleged crime scene locations. In short, his ability to effectively prepare for trial is eliminated by being in custody. If a judge feels insulted or disrespected by a lawyer who advocates on behalf of his client, the judge might be in the wrong profession. As the Supreme Court of the United States warned over 50 years ago, a trial judge must acknowledge, quote, the importance of assuring alert self-restraint in the exercise of the summary power for punishing contempt. In McDonald, a lawyer was held in contempt based on a failure to obey a judge's instruction to avoid certain topics during questioning of a witness. The lawyer violated the court's directive and was held in contempt. The Supreme Court reversed, holding that the lawyer's conduct was not susceptible to summary contempt. The argument of a lawyer in presenting his client's case strenuously and persistently cannot amount to a contempt of court, so long as the lawyer does not in some way create an obstruction which blocks the judge in the performance of his judicial duty. The petitioner created no such obstacle. Apart from the insufficient evidence to support the contempt conviction, the procedure used by the trial court was grossly insufficient to protect Mr. Steele's right to due process, including the right to prepare a defense, the right to form a notice of the charges, the right to present evidence, and most importantly, the right to an impartial judge who was not embroiled in the controversy that spawned the alleged contemptuous conduct. The most eloquent discourse on the improper use of summary contempt proceedings in response to a lawyer's in-court behavior appears in Justice Frankfurter's dissenting opinion in Sacker v. United States. The Sacker case involved the prosecution of various individuals charged with being communists who advocated for the overthrow of the government. The trial was unusually long, though, of course, the definition of long has been drastically amended by the proceedings in the YSL case under consideration. In Sacher, Justice Frankfurter observed in his dissenting opinion, quote, "In many ways, it was a trial wholly out of the ordinary. In its length, the nature of the issues, the political and emotional atmosphere in which they were enveloped, the conduct of court and counsel, the conflict between them. After several weeks of proceedings on pre-trial motions, the trial proper got on the way. 9 weeks were consumed in getting a jury and 30 more in trying the case to the jury. Justice Frankfurter then explored the dangers of summary contempt procedures, which were invoked at the conclusion of the trial to punish the defense lawyers for their supposedly contumacious conduct." And here is from that. "That contempt power over counsel, summary or otherwise, is capable of abuse is certain. Men who make their way to the bench sometimes exhibit vanity, irascibility, narrowness, arrogance, and other weaknesses to which human flesh is heir. Most judges, however, recognize and respect courageous, forthright, loyal conduct. They rarely mistake overzeal or heated words of a man fired with a desire to win for the contemptuous conduct which defies rulings and deserves punishment. They recognize that our profession necessarily is a contentious one, and they respect the lawyer who makes a strenuous effort for their client. The power does not authorize the arbitrary imposition of punishment. To dispense which indictment by grand jury and trial by a jury of 12 does not mean the right to disregard reason and fairness. Reason and fairness demand, even in punishing contempt, procedural safeguards within which the needs for the effective administration of justice can be amply satisfied, while at the same time the reach of so drastic a power is kept within limits that will minimize abuse. While experience has shown the necessity of recognizing that courts possess this authority, experience has also proven that restrictions appropriate to the purposes of the power must fence in its exercise. The particular circumstances of this case compel me to conclude that a trial judge should not have combined in himself the functions of accuser and judge. For his accusations were not impersonal. They concerned matters in which he personally was deeply engaged. 20 years later, the Supreme Court warned that judges who cannot accept criticism from lawyers cannot resort to summary criminal contempt proceedings without necessity. And here is from that case. Therefore, the vehemence of the language used is not alone the measure of the power to punish for contempt. The fire which it kindles must constitute an imminent, not merely a likely, threat to the administration of justice. The danger must not be remote or even probable. It must immediately imperil the law of contempt. The law of contempt is made for the protection of judges who may be sensitive to the winds of public opinion. Judges are supposed to be men of fortitude, able to thrive in a hardy climate. And this is Craig v. Harney. Appellate courts in Georgia apply the same standards when considering whether summary contempt proceedings are available to address lawyer misconduct. When the judge is embroiled in the controversy, the case should be heard by a different judge. Here, Judge Glanville repeatedly decried the violation of the sanctity of his chambers, exposing his personal animus, albeit unjustified, about what occurred. Case law. And case law and case law. Judge should be disqualified from conducting the contempt hearing where the judge's impartiality might reasonably be questioned, and that is one of the rules that is since then applied. And in Adams, where the judge has become personally embroiled in a controversy, the contempt case should be heard by a different judge. Judge Glanville's hostility towards Brian Steele personally was shown by his refusal to ask any other defense attorney how any of them learned about what happened during the improper ex parte meeting, despite the fact that at least one other lawyer, Keith Adams, told the judge that he too knew about the ex parte hearing. Yeah, Judge Glanville was really surprised because he had shouted on Mr. Steele for a few minutes. And then Mr. Adams, co-counsel to Mr. Steele, said, I also knew about this. And Judge Glanville's answer was, well, I didn't ask you the question. Which, let's continue. Procedurally, the trial judge's decision to conduct an abbreviated, nearly non-existent hearing, claiming that urgent action was needed to address Mr. Steele's recalcitrance, was without any foundation. Whether Mr. Steele answered the question or not, the trial of the defendants was going to proceed, and indeed did proceed. Mr. Steele's refusal to waive his asserted privilege did not delay the trial for a minute, nor was his refusal to answer the judge's question the type of obstreperous conduct that required immediate condemnation in front of the jury. There was certainly no need to hold Mr. Steele in contempt in order to stop any misbehavior. Moreover, the judge's curiosity, notwithstanding, it simply did not make any difference who told Mr. Steele what happened in the improper ex parte conference. Perhaps the judge thought that whoever spilled the beans was guilty of an offense. But what offense? Not only was there no ad hoc decision to seal the proceeding, the judge himself was obligated by the Judicial Code to furnish a transcript to all lawyers. The prosecutors were obligated to reveal the exculpatory information to the defense attorneys. The Ninth Circuit discussed the condition that must exist to trigger holding a summary contempt proceeding. In Gustafson, it is neither necessary nor appropriate for us to decide whether Gustafson's remarks were sufficiently obstructive to constitute contempt within the meaning of 18 U.S.C. Whether or not Gustafson's remarks constituted a quote-unquote material obstruction, his conduct was not punishable under the Federal Rule of Criminal Procedure, Rule 42A, because there was no compelling need for immediate action. In those cases of attorney or pro se party misconduct in which court have applied Rule 42, and with emphasis, there was a compelling need for immediate punishment because the conduct at issue had caused not insubstantial and entirely unnecessary delays which substantially disrupted the trial. This is really interesting because if this rule was applied to general delays, unnecessary delays, then the prosecution here would be held in contempt all the time. In this case, too, there was no compelling necessity to dispense with the most basic and elementary aspects of due process. Lawyers are not second-class citizens. A lawyer has the right to be advised of the nature of the charges being leveled against him, to have a fair and impartial judge who is not embroiled in the controversy, to have time to retain counsel who is able to prepare a defense, and to present witnesses in support of a defense or to mitigate punishment. Conclusion. In conclusion, there was no basis for the judge to violate the code of judicial conduct by conducting an ex parte hearing. B. No basis for the judge to violate the code of judicial conduct by failing to tell the defense attorneys about the ex parte proceeding after it occurred. C. No basis for the judge to demand an answer to his question. D. No basis to ignore Mr. Steele's assertion of privilege. E. No basis to jail Mr. Steele for civil contempt. F. No basis to conduct summary criminal contempt proceedings. G. No basis for Judge Glanville to conduct the proceedings without referring the matter to a different judge who was not embroiled in the controversy. H. No basis for concluding that Mr. Steele was actually engaged in any contumacious conduct supporting a finding beyond a reasonable doubt that he was in criminal contempt. I. No basis for imposing a sentence at the maximum level, 20 days in jail. Mr. Steele's unwillingness to succumb to the judge's unauthorized demands should be applauded by this court. Regularity and transparency must prevail over arbitrariness and secrecy. The judge has now been recused based on his inappropriate behavior after holding Mr. Steele in contempt. The prosecutors have been schooled by the judge who replaced Judge Glanville about their failure to turn over the Brady information from the ex parte meeting. Well, not enough. Not enough. To some, this episode was a sad and regrettable incident in the history of Georgia criminal procedure. Yet, based on Mr. Steele's fortitude, the recusal of Judge Glanville, and the cautionary warning directed to the prosecutors, in the end, the closing chapter, reversing the conviction, should be cause for celebration. This court should reverse the lower court's decision holding Mr. Steele in contempt. Respectfully submitted, Edward D. Tolley, Donald F. Samuel, Amanda R. Clark Palmer. Certificate of compliance. Yeah, so there it is. That is a really strong amicus brief that more or less tells the Supreme Court that Judge Glanville's conduct was so bad, they more or less should recommend sanctions. That is my reading between the lines, so to speak. Oh, hello, Mr. Jingles. Hello, Mr. Folks, it is Mr. Jingles. You all know him, you all love him, and you all are a part of Mr. Jingles Viking Thugs, an organization devoted to Mr. Jingles Viking Thugs by hitting the like and subscribe, and nothing we do applies to any other voluntary members of JVT, just so you know. Okay, if you want to know more, check my streams, and I will see you all in the next video or stream. But until then, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? See you. Bye-bye.